Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It's Tuesday, November 16th, 2021. Well, what's the significance of Tuesday? Well, lots of things today. The first is that, well, it's our Tuesday Night Live show. We've made lots of these shows over the last couple of years. Try not to miss too many of them. So we're here. And then immediately following this show, which roughly goes about an hour, then we'll go to our Patreon show for all our Patreon members. So if you haven't become a Patreon, now is a good time to do so. I want to thank everyone for being here this evening. I appreciate you taking the time to join us. Understand you probably have lots of things that you could be doing. So the fact that you took the time to be with us does not go unnoticed, and I assure you it is greatly appreciated. All right, for those of you who do not know me, my name is Scott Reich. I am a practicing criminal defense attorney. Been doing criminal defense for now 26 years. Makes me feel old every day I think about that. But I hopefully, the significance of that for you all is that when I'm talking about a case, whether it's the law, the facts, or the procedure, you understand, and hopefully I'm, shooting you straight. I have no reason not to just tell the facts as they are and the law as it is, okay? That's what I'm trying to get out to everybody. We started this channel because I was so annoyed by seeing the evening news where people didn't know the difference between a motions hearing, a pretrial conference, and an arraignment. They had no idea. So I understand they have very limited time constraints in which they have to work under. So we started this channel, and here we are, 3 years later now? Maybe a little less than 3 years. But here we are, and almost at 200,000 subscribers. And there's no doubt in my mind that our subscriber count that was keeping pretty steadily, going up very steadily, literally for years, unless and until there's a big case that somebody at YouTube does not like. And literally, our subscriber count dropped to 0. They demonetized a lot of our videos. And then miraculously, weeks later, they look at it again and say, oh, yeah, I guess we can monetize those now. And the case that I think that obviously brought YouTube to take us out of the algorithm, so to speak, is we put in there, we were talking about, that's right, Kyle Rittenhouse. That's the case that kind of everybody has been watching for the last, I guess, almost 3 weeks now. And then, that's up there in Wisconsin. Then down in Georgia, we have the case regarding the 3 men accused of the death of Ahmaud Arbery. The prosecution just rested this afternoon. So we will see what, if any, evidence the defense wants to put on their behalf. Understand the defendant never has to testify. The defendant never has to put on any evidence whatsoever. The defendant never has to present any evidence. The burden always remains with the prosecution, and that burden never shifts to the defense for the defendant to prove himself innocent. So those are the two big cases, but I'm almost positive anything talking about Kyle Rittenhouse really tanked our numbers the last couple of weeks. But I think it was an important case to talk about. Why? I think because so many people are divided, whether it's through politics, what they've heard in the media from one side or the other. Some people think Kyle Rittenhouse is a poster child. Other people believe that he is, the Antichrist, that he is a white supremacist, gun-toting thug who does nothing but go around and terrorize people that are exercising their First Amendment rights. So it depends on what narrative, I guess, you have been listening to over the last 2 years as to what you kind of went into the case listening to, although I was pleasantly surprised, and this is why we have this channel, is that there were several people that said, I thought that Kyle Rittenhouse was absolutely guilty, but then I watched the trial and, I have my doubts. Okay. And I'm sure there's lots of other people that viewed it and said, I thought he was innocent, but I'm not sure. He's clearly guilty of poor judgment. I get he thinks he was out there trying to, guard people, protect property. I get that. But poor judgment, as they say in the military, good initiative, poor judgment. If I was his mom, we haven't seen his dad, even though his dad supposedly lives up there. It's always been the mom on TV. But it's the kind of situation you're wondering, you always have to wonder, the family pops up when somebody gets in trouble, when they show up in court, it's like, oh, the family here's always such a good baby, such a good boy. Well, where were you when they were out running the streets at night? Okay. I get it. He was out protecting property. Some people think that's the greatest thing to do. If you were my kid, I would have had him at home saying you're not going anywhere near that trouble because, well, trouble happens in those type of exact circumstances. And now Kyle Rittenhouse literally waits while the jury deliberates as to his fate. Is he going to go home? Is he going to be remanded at the announcement of the verdict and, spend the rest of his life in prison? I don't know. We'll all pretty much find out together. They don't tell anybody. The judge will collect the jury verdict from the foreperson via the bailiff. The judge will look at it, make sure all the signatures are in the right spot. And if there's any boxes that need to be checked, that they're properly checked. Other than that, that's the first time the judge sees what the verdict is. And I can tell you from an attorney perspective, all right, from an attorney perspective, whether you are a prosecutor or whether you are a defense attorney, this is the worst time, okay? And I take that back. It is the second worst time during a trial. Everything else you can deal with, right? Objections, evidence, witnesses, you can handle that. But when the jury goes back and deliberate, it's completely out of your hands, all right? And so I say it's the second worst time of a trial for an attorney, and also the defendant, I might add, I would say, is because when you can't do anything, but then they come to you eventually, and some point they'll say, you'll get a call and you'll see the number from the clerk and you'll be like, oh my gosh, they have a verdict. And they'll say, oh, we have a question, or oh, whatever. Or if they say you have a verdict, I don't care how many trials you've done, you still get that sinking feeling in your stomach of, oh man, they have a verdict. Oh boy, did I do everything I could have done? Oh boy, you start, thinking about it and like, okay, we'll just have to wait and see. Because when they say they have a verdict, that is the worst moment. So this right now is the second worst moment. It's a helpless feeling. You can do nothing but wait. Some people think, well, I'll just go do some work. You can't, okay? You can't. So we'll take a quick recess here, but then we'll talk about what do you think about the fact that the jury is still out? Should we read anything into it whatsoever? I'll give you my perspective, and then we'll take your questions. Make sure you put something in the chat, and we as we state, we never ask for or beg for any kind of a super chat, but I'm telling you, it certainly highlights it in the comment section, and it definitely increases your odds of having your question brought to my attention and then asked and hopefully answered as well. So let's take a quick recess, and we'll be back in, I think, like 35 seconds. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. All right, we are back. So the jury has been out now since, I think, what was it? I was watching 9 a.m. today, roughly. Final jury instructions were read. They did something that I've never seen anywhere before. Now, I've seen the magic, the bingo ball roller thing before, but that's normally when you select the potential jurors. And I've seen that done in federal court. You have all the jurors, they have their little number, they put them in there, they spin it up, and they pull them out randomly. I've never seen a situation where you have so many alternates, and I understand why the judge had so many alternates, is you just didn't know if something was going to come up and jurors were going to have to be excused. You know, we saw that in the Derek Chauvin trial where they lose 3 jurors, I think, throughout the kind of start to finish. And so it's good to have additional alternate jurors, right? So I've never seen it, though, where, you know, you usually have your 12 jurors, your presumptive. Number 13 is your first alternate. Number 14 is your second alternate, and so on and so on. So when the defendant, and I get, you know, they're like, hey, let's have the defendant pull the numbers out. But I've never seen that where basically they randomly pick 6 people and say, you all are the alternate. Now, there's nothing that says they can't do it that way. I'm just telling you, I've never seen it. And when I was watching it, several people were commenting that they had never seen that before either. Apparently it's a Kenosha, Wisconsin thing, but it works. That's their system. And, you know, that's how the people, you know, they're picked. You know, I think we talked about in the video today, normally when you have your pretrial conference or the morning of trial, the judge will say, you know, defense, have your client pick a number between 1 and 13, 7, 6, whatever. All right, whomever winds up in that chair at the end of jury selection is our alternate juror. Nobody knows who that person is going to be until they get into that seat. So, you know, that's what normally happens. So now the question becomes, oh my gosh, they've been in there since, say, 9 a.m. this morning. So 9, 10, 11, 12, 1, 2, 3, 4, 5 until they go home at the end of the day, right? They get their lunch catered in, right? Remember, in most jurisdictions, they don't get the free lunch until they actually start deliberations. And the alternates, I'm assuming, are also getting catered lunch in their separate room where they get to talk about anything but the one thing that has brought them together, which is this case. And they can't talk about the facts because if an alternate did have to jump in and participate, the jurors would have to basically start their deliberations from scratch because the new juror would come in, all right? So they're doing that. So they've been in there, you know, roughly 8 hours or so. Haven't seen any reports if, you know, we have smokers in the bunch or they need to go out and take a smoke break. You know, sometimes you can tell when the jurors go out on a smoke break or they want to go take a walk outside. You know, and kind of see if factions have formed. Or maybe it's just coincidence. Here's what you can really look at and say, well, it wasn't a quick verdict. Oh, it's going to be hung. No, you can't say that, okay? I mean, this trial went on for roughly, 2.5 weeks, I think is a good phase, 2.5, 3 weeks from the time you started kind of the jury selection. That's a long time, okay? That's a lot of evidence, 2 weeks of evidence being presented. The jurors, you know, they've just been sitting there listening the whole time. Now they have to go through all those jury instructions. They have a packet of the jury instructions. Any evidence that's been admitted into evidence, they get a copy of that. So, and you never know how they're going to start. Normally, hopefully, they start out trying to pick who wants to be the foreperson to kind of see how are we going to handle this meeting? What's the best way to do it? How should we go about it? Should we take an initial vote? Should we, just go through, talk about each charge one by one, talk about the evidence in general? What do you think? Kind of get a idea of where everybody stands or doesn't stand, so to speak. And then they can start going through and looking at the evidence, reading the charges. And I will tell you, ladies and gentlemen, I don't think you can predict guilty, not guilty, whether it's quick or fact. Yes, there's some juries that you think, I think the fastest I ever had was about 3-minute not guilty, but it was just a stupid case, right? It never should have been brought. Everybody knew it. They literally going like, who guilty, not guilty. It's like 5:00 on Friday afternoon. We're out of here, right? But this is a very serious case, all right? First, you have 2 dead men, 1 severely injured. You have a teenager who could potentially spend the rest of his life in prison. These jurors, I would submit to you, and they would say this afterwards, was that this is probably the most important decision that they've ever had to make in their life, okay? But this is why our jury system is so, I think, beautiful, right? How many have ever had family over at the holidays, or even friends over? They all come over and you're going, we're going to go out to get some to eat. How easy is it to get everybody to agree you're all going to go to one place and get a particular kind of food, right? Doesn't happen. It's very difficult to get 12 people to agree or disagree on just about anything. It's easier to disagree, I guess, right? So now you have 12 people who've never really met. They've got to know each other in the mornings when they assemble, in the evenings when they gather their things and go home, but they don't get to talk about the case. And so they actually have to sit there and, try to feel each other out to figure out, where they stand on the evidence that's been presented. But most jurors will admit that this is the most important thing they have ever done, or probably will do, and they understand the significance of it. And not the significance, this is not a case where, the American judicial system is going to crumble. It's not about that. It's not whether America survives or not. It's not about that. And I believe this is where most people get confused about the criminal justice system. Everybody seems like they want to pick sides, right? Haven't we seen this? Kyle Rittenhouse, he's the greatest thing since sliced bread. He was up there as a true patriot. He's doing guarding the stuff. And then you get the other people. He's a racist thug who shouldn't be out there with a gun. Who lets in a 17-year-old out there with a rifle? And everybody gets all excited. And they've made up their minds based upon what they think of Kyle Rittenhouse or, more than likely his political views. And this is what I say this. I've said this before, and people get all upset with me. When I say nobody cares about your feelings, right? The law really could give no care about people's feelings. Your feelings don't matter when you go to court. Oh, I feel really bad for the defense. Okay. A juror, a judge has one job to do in a jury trial, whether it's trial to the court or trial to the jury. It's not whether the defendant or the dead guy or the injured guy is a good person or is a bad person. It's simply about whether the act took place. And here, if the act took place, which no one really disputes that the act took place, it's not like it's an ID case. I mean, Kyle Rittenhouse says, yeah, I was the guy with the gun and I shot these guys but I did it in self-defense. Okay? And that's the only thing that matters. Under the law, the judge gives them the jury instructions, and we read them the other night, and we talked through the jury instructions. Nowhere did it say or give 2 cares about how somebody feels about, well, the defendant was such a nice young man, or the dead guy was such a big piece of crap, and I'm sure his family says he was a great guy, blah, 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 blah. Irrelevant. Only thing matters is, under the law, did the act take place? And if it did, was it the defendant? Not a big issue here. And then it comes down to, was it self-defense? And a lot of people say, well, you go outside and you go out into a riot with a gun. And the DA made an argument. I'm telling you, I was watching the closing argument, and I literally was like, objection, objection. I wish the defense counsel had objected, because the prosecutor, in my opinion, his argument was way off base. He was absolutely misstating the law. Now, I get it. It's argument. And I've been in some jurisdictions where it's just seen as polite that you don't object during closing argument. Well, guess what? I don't care about being polite in closing argument. I care about my client getting a fair trial, and I care about preserving the record if they're convicted. And if I don't object, that issue is waived. Okay? Now, the judge sometimes can do it sua sponte, which means on their own. Fancy word. He can jump up and say, hey, Mr. Defendant or Mr. Prosecutor or Defense Counsel, stop it right there. Don't say it. But most judges aren't going to do that. But the reality of it is, I was surprised some of the things that didn't get objected to. So, I mean, that's really what it is. And I'm sure that makes some people unhappy. But like I said, I'm here. I don't have a dog in this fight with Kyle Rittenhouse. And I think it's funny, people are like, oh my gosh, Scott, I can tell your political leanings because you're so biased towards the prosecution. You think Kyle Rittenhouse is a great kid. No, I think his kid's kind of a knucklehead. What the hell were you doing out there? I get you were trying to be a good guy. You want to be a police officer someday, but you're 17, a freaking riot, in all honesty. Leave it to the professionals, okay? Leave it to the police. Now, here's the other thing. The police completely folded up there, which is why he was out there. Which just absolutely blows my mind. I mean, the police were there, but they weren't exactly putting up a big fight because nobody wanted to do anything wrong. They're like, well, they're mostly peaceful protesters out here. They've only burned a couple of buildings, okay? And I listen, nobody loves the Constitution more than I do. And you can exercise your freedom of speech under the First Amendment as much as you want. I am all for it. I will be out there helping you do what you need to do. But when you start burning and rioting, at that point, yeah, you've crossed the line, okay? So that's, kind of where we stand in old Kyle Rittenhouse. Really, like I said, people are like, oh, Scott, no, I'm just looking at the facts. And I remember when this case first came out, I was like, this is not good. I'm thinking they're going to crucify this kid, bad timing. And then some people stepped up and, he started getting a criminal defense fund. And I'm telling you, his attorneys, they did a very, very good job defending this case, okay? There's been a lot of criticism of the prosecutor. I think the biggest thing is he finally conceded at the end of all the evidence that, oh, yeah, by the way, the rifle is not shorter than 16 inches, therefore it's not illegal. For 2 years, the prosecutor has been touting that he came across state line. Julie, how many miles did he drive? Julie was quite offended. Frank and Julie behind the camera here. Julie was quite offended that he drove across state line. And then she realized that from, what was it, Nantucket or something, the town that he's from, and I'm probably mispronounced that, so my apologies. I'm sure I've offended somebody. But driving up there to Kenosha is like 12 miles, maybe 16, depending on how you MapQuest it. It's not like he was driving for hours and hours, like, I'm going to drive to state lines. I mean, you go to Colorado, I think it's an hour and a half to Wyoming border on a good day. So maybe 2, right? Probably 4 going east, 4 to 5, probably closer to 5 going west, a good 4 going south, when you're right in the middle of the state. So people are like, oh my God, he drove all that way. Well, and his dad lived there. Like, what's he doing there? Well, his dad lives there. So it's funny, like I said, people had formed so many opinions about the case beforehand, but you got to look at the facts, you got to look at the evidence. And so what my point that I'm raising here is these jurors, they know that a lot is at stake, okay? And it's not because the kid's 18. It's not because, the prosecution loses. Oh my gosh, is the town going to burn down? Whatever. And, I truly hope, whatever the verdict is, people respect the verdict, okay? Because you have to remember, that verdict is the combined judgment of those jurors. People that It basically said I can be fair and impartial, listen to the evidence, reserve judgment until I hear all the evidence in the case, and I'm given the facts, I'm given the law from the judge and apply those facts to the law. So it's the combined judgment of the community. So whatever the jury verdict is, it should be respected, bottom line, because whatever it is, they got it right. Okay? They got it right. Sorry, I thought the screen went black out in front of me, and I was like, did we lose everybody? So sorry about that. All right. So that's my take on the Rittenhouse case. Don't get too spun up one way or the other. Oh my gosh, it was a quick verdict. It was a slow verdict. No, it's going to be the right verdict in the sense of the jurors are taking their time. It has to be unanimous, ladies and gentlemen. Unanimous for guilt, unanimous for not guilty. They got to go through all the instructions. They have to read them. Remember, the first time they heard these instructions was when the judge read them and said, okay, here you go. Here's a piece of paper. We know you're not lawyers. You've been sitting here for 2 weeks. The defense and the prosecution each have their own spin on what the evidence means and what the instructions mean. So here it is. Go figure it out for yourself, right? It's going to take some time because they want to get it right. They want to get it right. Okay, let's see here. Yes, a big shout out to our mods. They're always great. I don't think we've had any real issues. For some reason, every now and then we get 1 or 2 people that just want to go to war with our mods. And, 99.9% of the time, I'm going to support the mods because, you can agree to disagree. Frankly, if you disagree, let's talk about it. I have no goal here to make everyone agree with me because, my opinions basically change just like they do in a real case in the law. It depends on new information that comes available, right? I think I told you the Rittenhouse case. My first thought was, man, this is not good. This kid is, and then people started sending me videos. I'm like, well, he's got something to work with. He's got some resources. He's got a shot. And I think the defining moment in the Rittenhouse case was when Mr. Gross-Cruz admitted that, so the first time he got pointed the gun at you and he shot you was when you were approaching him with a loaded firearm pointed at his head. And Gross-Cruz said, yes. If that's not self-defense, ladies and gentlemen, I don't know what is. I don't know how you define self-defense in any other jurisdiction if that is not it. And it's not, like I said, self-defense, we read the instructions. Some people didn't like it, but these are straight from the jury instructions. I think it's worth reading just one more time, okay? Self-defense is an issue in the case. In deciding whether the defendant's conduct was criminally reckless conduct, which showed utter disregard for human life, or was criminally reckless conduct, was criminally negligent conduct, those are lesser included offenses, you should also consider whether the defendant acted lawfully in self-defense. Remember, he may have killed people, he may have shot people, but you can still do that and act lawfully. Some people have this notion that if you kill somebody, you die. You should go to prison for the rest of your life. You are an evil person. Well, the law has created exceptions to that, ladies and gentlemen. So yes, we're not advocating people run around killing people, but if you do, you want to do it lawfully, right? And that would be on a self-defense. And there's some interesting cases that are going up to the United States Supreme Court regarding, the right to possess a firearm and a right to, basically you have a fundamental right to defend yourself. And how can you defend yourself if you aren't able to properly arm yourself? And so, we're going to have to see what the Supreme Court does. I think they're going to say that you have a right to a firearm basically just about any time, unless you're a prohibited person, and you can't, have it in various places. But for so many years, states tried to put restrictions on people carrying firearms. But in most states, at least where we live here, you can still carry open carry. In all honesty, what do police officers do? They carry open carry. Frankly, I'd prefer to have somebody I know, if they have a gun, that I can see it, right? But if they're going to conceal it, the whole point is that it be concealed and you not see it. So you never know. So anyway, we go back to the instruction. The law of self-defense, and this is obviously in Wisconsin, the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and that the defendant's beliefs were reasonable, right? So that kind of goes to the first guy. You got the guy that was swinging the skateboard, and then you got the other guy that was coming at him saying that he was going to, basically kill him and try to grab his gun and get it away from him. Did he use the appropriate amount of force? Was the defendant's belief reasonable? If it's completely unreasonable, I don't know. There gives an instruction, and this is what I think is important. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. Now, why is that so important? You don't get to play armchair quarterback, ladies and gentlemen. It's what he thought, what he believed at the time of the offense. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of the defendant's act, and not from the viewpoint of the jury now. No armchair quarterback, ladies and gentlemen. And what is the evidence thus far, right? Rittenhouse got up and testified. That's evidence. I felt I was in fear of death, serious bodily injury, that I acted reasonable. I had a reasonable belief that was going to happen. I used the jury has to decide those questions. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. So what does that mean? The government has to prove beyond a reasonable doubt. Not only have to prove that he did it, wasn't a whodunit in this case. It was a case of, was it reasonable? Did he act reasonably? The jury will decide that from the position of the defendant that night at that time, not 2 years later. And the jury has to consider the beliefs, and I'm sorry, they have to consider what was going on in his mind at that time, and they can't sit there and play armchair quarterback. Yep. Jay Wilbur, good says the judge said the closing arguments were not evidence. What's the point of rebuttal? Well, Jay Wilbur, great question. I'm glad I saw that as it was going by. Yes, the judge is absolutely correct. The only thing that's evidence are things that are admitted into evidence or witnesses' testimony from the witness stand. That's it. Opening statements are not evidence. It's simply a guide path, a little tour of where we're headed. This is what we believe the evidence is going to show. The closing argument is nothing more than that argument to say, ladies and gentlemen, this is the law. These are the facts. They can be interpreted differently. Believe them my way. Don't listen to the district attorney. Don't believe the defense counsel. He's sending you off on this, whatever the argument is, right? It's not evidence. It's simply to say this is what we believe the evidence shows and why the person is either guilty or not guilty. In the law, the person who has the burden always goes first, right? The prosecution has the burden of proof, never shifts to the defendant to prove their case beyond a reasonable doubt. So they get their first word, the defense gets their closing argument, and then the prosecution gets a rebuttal as well. That's just the way it is. It's the law, because they have the burden. Same thing if you're in a motions hearing, your motion, you call the first witness. If you present some evidence, then the burden shifts to the other side, say the state. but whoever has the burden always gets the last word. So hopefully that explains that. The jurors has expressed concern for their personal and their family safety if they say innocent. Jane, I haven't seen that. But, you know, I think I mentioned this story, you know, a couple of times. I had a guy once, you know, he was maybe accused of doing some things. And I thought, you know, things were great. I mean, things were like, you know, it's like things are going all right. The client was like, oh, my gosh, Scott, that was the greatest closing argument ever. The founding fathers would have been proud of you. You nailed it. First question to come from the jury room was, does the defendant have access to our home addresses? Ooh. The judge, you know, we all kind of look like, ooh, that's not good. Client asks afterwards, what does that mean? I don't know, but I don't think it's good. Not good, right? Needless to say, we crashed and burned. It was ugly. And then I suddenly went from the greatest guy in the world to the biggest bag of trash you'd ever seen in your life. You know, I want my money back. How dare you? You know, I'm not the one going around threatening people, right? But anyway, who turned down a great deal in my head. So, you know, the jury shouldn't, listen, nobody should harm the jurors. Nobody should threaten the jurors. I mean, that goes completely against our judicial system. They need to make their decision based upon the evidence or the lack thereof. Bottom line. If, you know, and if that, you know, they need to make their decision based upon the evidence. They knew going in that this was going to be a big deal. They should not be intimidated in any way whatsoever. Good evening, Holly R., who looks like is a member. Let's see here. Rebecca as well. Let's see. I think Dominic Black shows us Kyle for purchasing a gun for him, giving it to the kid, driving the kid to the location, and telling him they would be paid. And I can't remember if Mr. Black's being prosecuted or not. I don't remember that. Scott, can you talk about what the FBI is doing? Big news today. Not sure what referencing. Lots of things. I have I have several calls today with U.S. attorneys and other people. Anthony Hayden wants to know, why are the protesters allowed outside with bullhorns then? Well, they have a right to protest. You know, hopefully the people will see if they're trying to intimidate the jurors. Hopefully it doesn't work. One way or the other. Like I said, ladies and gentlemen, whatever the jury verdict is, that's their verdict. But whatever happens, nobody should harm a juror or their family in any way. That strikes at the very heart of the judicial system. And I would hope that if, God forbid, anything like that happens, that I don't care who did it, allegedly, if something happens, I hope it doesn't. But if they did, that somebody bring the full force and weight of the prosecution down on them like a ton of bricks. That strikes directly at the heart of our judicial system. So, Scott, what was your honest opinion of the prosecutor's performance? Mr. Binger, I don't think he did a great job. He almost seemed a little unprepared. I think he was way off base. I think his questioning regarding the staying silence, of Rittenhouse's keeping silent, not making any statement until he got to court, completely inappropriate. That is literally baby prosecutor 101 type of stuff. So he did that. I thought it was completely over the line. And frankly, I'm surprised the defense didn't object sooner. And I'm surprised the judge was as calm as he did. Because I think a lot of judges I would have been in front of would have declared a mistrial immediately based upon the prosecutor's conduct, for sure. Okay, maybe you get one pass because you did it. You get admonished. People are like, oh, this judge is... Frank, the defense attorneys didn't do anything that would warrant getting yelled at like the prosecutor did. I didn't see anything, and I would tell you if he did, like, oh, I think you crossed the line there. That's why the defense didn't get yelled at. They didn't do anything that crossed the line. The prosecutor does this. And then I'm telling you, I swear to God, my first degree murder case, right? You know, I'm a young guy, first homicide case. I have a very experienced first chair, you know, and you know, he'd been around a long time. He was great guy. Absolute pleasure. Learned a ton working on him in on that case. And one thing became very evident during the course of the trial, that, you know, the prosecutors at first were like, oh, yes, this is, you know, we're here to present justice and be fair. And, oh, all the evidence is going to point that the bad man over there did this bad thing. Well, as the trial progressed, and there were a couple of key moments in the trial where the defense did really well. And it became very obvious that the prosecutors at that point started, for lack of a better term, to cheat because they want to win, okay? Prosecutors are supposed to win every case, ladies and gentlemen. They really are. And they know that. And they don't like to go back to their office saying that they lost, particularly on a homicide case. And so when they think they're losing, they start playing cheap, and they know for most of it that they're going to get a pass by the judge because they're the prosecution. It's just the way it is, okay? Unless you have a real strong judge that isn't going to take that crap, bottom line, okay? And yes, we did win that case. We did win that case. And, you know, and they just started to try to cheat. And unfortunately, we had a strong judge that shut them down hard. And that's what it takes, you know. A judge, you know, there's a great quote, and I wish I had it in front of me, but Justice Scalia wrote it, and it said, you know, if you want to be a good judge, okay, and the way to tell if somebody's really being a good judge is, if you don't come to the conclusion that you like every time, probably means you're being a good judge. I had a case just the other day, and it was pretty straightforward. The statute was rather clear, but the judge didn't want to let this case go, and said, "Well, you know, this is treatment court. We're supposed to get treatment." I'm like, I don't care, because guess what? The law doesn't care about your feelings, Judge. The law doesn't care about my feelings. The law doesn't care about my client's feelings. If they did, he wouldn't be here, right? Because his feelings would be hurt. Nobody cares. And that's what people, they just don't get it when it comes to court. Nobody cares about your feelings. That's it, okay? It's about the law and it's about facts. Did something take place or not? And I told the judge, these are the facts. This is the law. You have to do this. The case should be dismissed. And she says, well, I don't know. I really like to keep, you know, we want to get everybody treatment because we want to feel good. It makes us all feel good. And then we can have our treatment court class at the end and everybody have a big hug and big thank you and blah, blah, blah. And I'm like, Judge, I understand. But sometimes in the law, we don't always get the result that we want. Guess what? My client wants to go home. The law's on his side. The facts are on his side. You don't get to do it. Guess what? That judge rotates out. 2 weeks later, new judge is like, of course the motion filed by Mr. Reich and his firm is correct. Case dismissed. Right? Because nobody, I mean, and I'm telling you, this is why lawyers get the bad rap. Okay? We get accused of being the bad guys. Oh, you don't have a heart. Okay? I have a heart. Just ask the lovely Miss Kristen. I keep it in a jar of formaldehyde on my nightstand. There's my heart right there. Okay? We get accused of being insensitive, callous, because you train and you think like a lawyer. Okay, that's really nice. You can tell me all your feelings all day long, but what's the law? What's going to be the end result? That's the only thing I care about. Okay, I've had people literally, okay, now that you've just spent the last hour venting, and I hope you feel better, but it still doesn't change the law. So what would you like to do? Right? So it's just the way it is. Rose, is it normal for the jury to have 36 pages of instructions? Normal case is probably 15 to 20. 36 is given the number of charges. Yes, the lesser included offenses. That seems reasonable to me. I've seen jury instructions where there's hundreds of counts, where literally you have hundreds of pages of jury instructions. So yes. Okay, it looks like all the comments stopped, apparently, when I said that, nobody cares about your feelings. Scott, if the jury comes back guilty, can the judge issue a directed verdict? And I don't know what they call it in Wisconsin, but it'd be basically a judgment notwithstanding the verdict. Maybe, but most judges won't do that unless they just think there's no way that the jury could have reached that particular result. Normally, you see that only in civil cases because, sometimes, there's caps on damages and the jury goes, we're going to have $1 bazillion, and the most they can get is like $250,000. So, very unlikely. I would doubt the judge would not honor the jury's verdict. However it comes back, it's the jury's decision. It's not the judge to substitute his judgment for the jury. The judge's opinion really doesn't matter. He's got a job. Call balls and strikes as it relates to the law, and do sentencing, rule on the legal issues, call balls and strikes during trials on issues that come up, and then sentence if there is going to be a sentencing hearing. So. Let's see here. Medic JJ, just would like your honest opinion as to why you feel that strong. Let me see. What are you referring to? Facts don't care about your feelings. Are you using StreamYard? It crashed earlier today. No. Greetings from Ireland. Good evening, Irish technical thinker. Sorry, I'm not sure I understood the question. I don't think we'll have I think the jury's going to be out. I'd say maybe. Thinking maybe tomorrow afternoon at the best. Yeah. How do people schedule a trial like 4 days for Josh Duggar? Rhymes with hugger. Easy. That's not a complicated case, right? They seat a jury. They bring in their lead detective, say, what did you do? What did you get? Information did you get? What did you do? We went and found the computer. What did you do when you get the computer? Well, we went and searched it then. We found all these images. Not going to take that long. 4 days. Most trials don't go 2-3 weeks. Most homicide trials, 5 days, including jury selection. It's not that complicated. It's an assault gone bad. Sometimes the way you got to think about it. Really it is. It's assault gone bad. Matt P. If found guilty, what does that mean for the law of self-defense? It just means that the jury didn't find it to be self-defense for Mr. Rittenhouse, if that's what they find. What happens in this particular trial doesn't make the whole law of self-defense go away. If you had a different jury, they could go completely opposite of what this jury comes out to be. So it doesn't, I don't think it means anything to it. Self-defense has been around forever because people have always said they've been justified, if they had to defend themselves. It's always existed. It's not going to go away. There's always little nuances to it. It changes a little bit here and there. But I think generally most people recognize self-defense. You don't have to retreat. You shouldn't have to, exercise every last means available to get away. somebody's trying to harm you or your family, you should be able to defend yourself accordingly. That's just my humble opinion. So I don't think it affects anything like that. Scott, when I was modding for the trial, one of our subs told me you said that typically the rule of thumb for jury deliberation is trial time is 1 hour for each day of the trial. Is that correct? No. Trial prep, Gen B. So generally, if you have and this is why people think, oh, you just show up to trial, it's no big deal. Oh, no. In all honesty, trial is the easy part. It's all the preparation that goes up to the trial. General rule of thumb, for every day of trial, you figure 2 to 3 days of prep for that one day. Now, it may not all be at one time, but that's what you generally have to estimate. Okay? So let's say you have a 5-day trial. You probably had 15 days of general preparation. May not have been all at one time, not 15 days altogether, but in the course of it. But that's a general rule as to what you look at, and that's the way we look at it. We try to figure, okay, here's an estimation of time and cost. Well, it's probably going to be a 5-day trial. You got that fee, okay, and then you got this. Yeah, it's going to get expensive, right? So yeah. Is Wisconsin a castle state? I don't know. For those who don't know what a castle state is, basically a castle state is you have a right to defend your castle. You have a right to defend your home, right? That's pretty fundamental. Some states say, like Colorado has we refer to as our Make My Day law. Somebody comes into your house uninvited and you believe that they're going to threaten you with some sort of harm. You can basically shoot first, ask questions later. And people do. So rule of thumb, don't go into somebody's house without permission. You just shouldn't do it. There's an example. It wasn't my case, but I remember there was a young lady returning from a party up in Boulder. Boulder is where the University of Colorado is located. And apparently she was perhaps intoxicated from a few adult beverages. And she stumbled her way into a home that was not hers. And the owner of the house, reached into the nightstand and fired the gun, hitting her in the hip. Dark house. You would think, oh my gosh, dark house, shooting at people randomly. You don't know who it was. And, the woman got charged for trespassing. Okay? That's kind of the castle doctrine. You have a right to protect yourself in the house. Now, before you start shooting people, always consult your local law. Okay? Talk to a lawyer. Just be smart about it. I had a friend, swear to God, this is a true story. A drunk guy comes to his house. He left the front door open because his daughters were they were out. They were in high school. I think they were coming home. And before their curfew, my friend and his wife were upstairs and they hear the door open and they don't think much about it. They just figure it's one of the daughters coming home and, figure they'll go off to bed. And nothing, it's just weird. I thought they'd come upstairs by now. And he goes downstairs and there's a guy sleeping on his couch, completely drunk, hammered. He got his gun, didn't shoot. He probably could have and not been charged, but he exercised, he was able to assess the situation, figure out the guy snoring on his couch, probably better not shoot him. So, yeah, let's take a couple more questions here before we go. Yep, the law and the facts. So let's see here. So hopefully you all, I answered your questions one way or the other by my comments this evening. Let's see. Can he be found acting in self-defense for the first victim and guilty of the other victims, or is it all or nothing? The jury can find him guilty of all charges, none, or some of others. They have to look at each charge individually. Just because you're found guilty of one doesn't mean that you can be found guilty of another. They have to look at it as each individual case on a case-by-case basis. I think you're going by your politics instead of what's right and wrong. Then people really are not thinking clearly. I think if you're going by your politics instead of what's right and wrong, yeah. Like I said, listen, everybody has politics. Everybody has their political beliefs, okay? But when you go to the court, you got to shut them off. That's the difference, okay? Because your political beliefs may not be the law. What you think the law should be, there's lots of things that I think the law should be, but I have to give my clients the advice on what the law is, not the way I think it should be. You know, many times I told the clients, hey, if you're up to me, man, I send you home. But it's not. I got to deal with reality here. And that's the thing, is that most people just don't want to deal with the reality of the law. So, see, Irish technical thinker. I'm a legal and licensed firearm owner in Ireland. Which is great. But like here, everyone talks about, oh, do you have a license for this? Do you have a license for that? What the hell do I need a license to exercise my right for? Right? Everybody asks, oh, did you register that gun? I fill out the paperwork when I buy a gun. I've never registered a firearm with anybody in my life. I don't even think I did in the military, although because I think I lived off base. If I lived on base, I'd have to let them know where the money. Lists. I mean, having to register a firearm, that's the same in the equivalent, in my humble opinion, is having to go and register as a sex offender. The government should not keep lists of people to say, these are the people we're going to go get when we think something's gone wrong. Okay? Just saying, ladies and gentlemen. Government having lists of people is never, ever a good thing. So, financially, does it make sense? And it's really a case you likely won't win regardless of the jury. I think they will let him go. The outraged people can blame the jury. Yeah, I mean, we'll just have to see. Whatever the juries say, whether you like it or not, that's their decision. I don't think the judge is going to do it. John J. College alumni Michael, thank you for answering my questions. I honestly think he wins an appeal if found guilty. Well, just remember, general rule here is 2%. Of all the cases that go to trial where the defendant loses, and the case goes up on appeal, guess what? 2% come back on appeal. You hear about the big cases like the Bill Cosby case. You hear about the most cases come back with the court will say, although there was error, it was harmless. And if it was so outrageous, a lot of them figure that, the court would have corrected it or granted a mistrial. So, if the court was going to grant a mistrial, he should have done it. I don't put my faith in appellate courts. That's probably it. You never know what they're going to do. Just like a jury. I had a case recently, and it was up to the United States Supreme Court, and it was set for a hearing. They actually went into little conferences where they decided whether they're going to take it. It didn't make it for writ of certiorari. But the issue that was presented and the issue that was briefed by both the defense and the prosecution was not what the court wrote about at all. Like, they completely missed the issue and didn't even address the issue that everybody thought was the issue. I mean, even the prosecution was like, well, we won, so what do we care? But yeah, we agree, So your legal issue is only as good as the judge that you have before it, okay? If you have a good, strong judge that's smart on the law, he may rule your way. You may win. They may appeal on a interlocutory appeal where it goes up to the Supreme Court and says, hey, the case can't go forward, Judge. We need to reverse this judge. And, a lot of times they do. So don't hang your hat. I tell clients all the time, appeals are great. You have an absolute right to an appeal, but don't hang your hat on winning on appeal. No guarantee. at all. So don't do that. So, all right. So I have court tomorrow morning. I don't think the jury will be back, but if they do, we'll bring it to you. And if I have advance notice and I'm here, I will be here to share the verdict with you all, whether it's tomorrow or Thursday or Friday. And, you know, obviously, if you haven't done so already, subscribe, hit that like button, share it with a friend. Hopefully, you know, we didn't offend too many people tonight. Sometimes when we tell the truth, some people don't like it. I get more people sometimes that tell me, Scott, I've been with you from the beginning. I've been a loyal person. I have ordered your gear on your merchandise that you sell. Great. But tonight, I disagree with you on a particular case, and therefore I am unsubscribing to you. And I just sit there and say, sometimes everybody, all right, thanks for watching. I mean, what do you want me to say? Like I said, this isn't here to say, hey, come join the Scott fan club and agree with everything that I say and have people, you know, sit in an echo chamber. We started this channel to talk about the law, the way it is. So, yeah. So let's thank our mods. Let's thank Frank, hardest working man in show business, Julie, also one of the hardest people in show business, one of the hardest working women in show business, keeps things going. Surprised it's busy. People just don't realize, and not to digress too much, but there's more work that goes into this than people say. You know, and trying to get it right and trying to put out a good product. I remember looking back at some of my early videos and I'm just like, oh my gosh, I can't believe I did that. So we've tried to do better, and you know, we'll see. And for those of you who haven't noticed, the bookshelves are back. Did you notice the bookshelves? Okay, and just for the record, I think we can see it here. Let me move this little thing here. Okay, just for the record, all right? That is not Mussolini. That is Lieutenant General Chesty Puller, one of the greatest Marines ever to serve, okay? I'm not related to him. He's just a great general. When surrounded by the Chinese in the Korean War, completely surrounded, winter, men freezing to death, and they come to him and said, "Sir, we're surrounded." And his response was, "Good. We've got them right where we want them." You have to have that kind of fighting spirit, ladies and gentlemen, to be a lawyer, okay? And like I said, I meant this before, and I'll say it again. Anybody can go to law school and become a lawyer. Just about anybody can be a litigator. Not everybody can be a trial attorney. And still, the best trial attorneys are prosecutors and criminal defense attorneys, swear to God, and frankly, criminal defense attorneys. So, just saying. Super Dave, I don't think Kyle's sleeping well tonight. He looked scared today. He looked very scared. As well, he should be, because he does not know his fate, and he will find out the same time as every single one of us. So, all right. Thanks for watching. Like I said, if you haven't done so already, please hit the subscribe button. If you haven't become a Patreon member, please join. You can still join us this evening. Be there in about, 5 minutes or so. And the conversation will continue. But there, guess what? We're going to do the Magic 8 Ball. That's right. Oop, wrong hand. Magic 8 Ball. Right there. There's the Magic 8 Ball. We'll have our question in a Magic 8 Ball. I think the appropriate question tonight will be, what does the Magic 8 Ball think as to whether Kyle Rittenhouse will be found guilty or not guilty? And even more importantly, that's right, you can call in if you're a Patreon member, and we'll have a conversation. So, all right, thanks for watching. We'll see y'all next time, and we'll see our Patreons in about 5 minutes. Have a wonderful night. See you next time on Crime Talk.